Welcome to today's seminar on understanding your rights to unlimited term employment contracts at universities and private schools. This session, organized by the General Union, aims to empower educators by shedding light on the legal provisions that enable secure and stable employment through unlimited term contracts, or UTCs. In 2013, Article 18 of the Labor Contract Law was introduced, paving the way for unlimited term contracts. This groundbreaking legislation allows workers to apply for UTCs if they have completed 2 or more fixed-term contracts, spanning 5 years or more. However, it's crucial to note that the employer must accept the application, and the working conditions must remain as those found in the limited term contract. Article 8 of the Labor Contract Law is a crucial safeguard that protects your working conditions. It states that an employer cannot unilaterally change the terms of your labor contract in a manner that disadvantages you. Any changes to your working conditions must be agreed upon by both parties. Article 9 provides some exceptions and conditions around when changes may potentially be allowed. Article 10 provides guidance on how and when changes to working regulations can be made by the employer. It states that changes must be reasonable in light of the disadvantage to the worker, the need for the change must be justified, the new regulations must be appropriate, and the status of negotiations with unions must be taken into account. Employers have put out a lot of misinformation about UTCs to persuade workers not to apply. Think about it. If an employer doesn't want you to get a UTC, it must mean UTCs are a good thing for workers. Now, let's answer some of the questions listed on this slide. This slide covers what elements a UTC contract should and should not contain. A UTC contract should include your working conditions, especially salary and payment information, as they were at the time of your conversion to an unlimited term. A UTC contract should not have an end date or disclaimers that allow the employer to unilaterally change your conditions or salary based on the school situation. Definitely, one of the biggest myths is that an employer can no longer raise your pay as changes to the contract are not permitted. Article 8 permits any agreed upon changes that are not a disadvantage to you. Additionally, you will still receive the benefits of any collective agreements negotiated by the union for improved wages and conditions. Another common scare tactic used by employers is claiming that if you get a UTC, you'll have to retire. This is simply not true. Retirement is based on the employer's working regulations and is not directly caused by having a UTC. In fact, for many workplaces, the retirement process for UTC holders is similar to that of regular workers. Retirement at a certain age, followed by potential rehiring on limited term contracts. Japan has no mandatory retirement age, and employers must allow workers to continue until at least 65, with future legal changes underway to raise it to 70. Isn't it actually 10 years in a university? The quick answer is no. 2 important laws related to university faculty are the Act on Term of Office of University Teachers and the Act on Revitalization of Science and Technology Innovation Creation. Some universities tried to use these laws to argue for a 10-year exception before granting UTCs. However, most part-time teachers are not involved in research or special purposes covered by these laws. Recent court judgments have confirmed the union's position that the 5-year rule for conversion to a UTC applies to the majority of part-time university teachers. The union takes a firm stance against unilateral cuts in classes, or COMA, especially for those on UTCs. This is because Articles 8, 9, and 10 prohibit disadvantageous changes without agreement. The Labor Ministry has clearly stated that number of classes is a working condition that cannot be changed unilaterally. Currently, there are 3 court cases regarding this matter, and the GU will soon file a new one. These universities, where the GU has members, have worked hard to undermine unlimited term contracts after 5 years by illegally applying the tenure rule and even limiting how long a person can work at the university so that they will never qualify for an unlimited term contract. As you can see on this slide, our union has recently secured several wins for part-time staff at universities across the region. At each of these institutions, we've achieved positive outcomes for part-time workers, like removing a tenure exemption to continued employment guarantees at Kansai University. But that's not all. We've also made headway in the legal arena. The slide mentions 2 important court cases impacting university part-time workers. In one instance, a Supreme Court ruling limited a university's ability to avoid applying certain employment regulations. There's also an ongoing case where a teacher successfully challenged their term of office at the High Court, with an appeal currently before the Supreme Court. In summary, here are some important points to remember. Article 18 allows conversion to an unlimited term contract after 5 years, ensuring job security. Article 8 safeguards working conditions during conversion. Employees can continue receiving pay raises, bonuses, and benefits. The 5-year rule applies to most part-time university teachers. UTCs don't mandate retirement age. They provide stability, unlike fixed-term contracts. They allow building institutional knowledge, reducing turnover. And UTCs signal long-term investment in employees.